Hi, it's Ron Coleman. Welcome to our first session, our first class in our course about American civil litigation. I haven't ever done anything quite like this before, but in fact, no one has ever done anything quite like this before. That's the miracle of human intellection. What I would like to do over the course of this course, and I don't know how long it's going to last, and I don't know how long it's going to take, is to give a sort of an overview of how American law works, focusing again on civil litigation, which is what I do. Other than criminal law, what most people seem to be most interested in, which is how the courts work, focusing on the process, how disputes are resolved through litigation. We'll talk about the key elements of civil litigation, different stages of a lawsuit, all the stuff that happens before a lawsuit, all the stuff that happens between the initiation of a lawsuit and the trial of a lawsuit, if a case goes to trial, which very, very few do. A lot of the procedural, technical things, try to make them as comprehensible as possible. I'll be using some more on-screen aids tonight. Tonight, I'm just gonna talk to you though. I am recording this the day before the first episode, which I do plan, as promised, to upload on a Wednesday. So it's Tuesday here in Newark. I did want to wait until after hours to do it so that I don't have to worry about ringing phones. It does look a little bit spooky in my office, but I also want to start briefly by introducing myself. I won't be so presumptuous as to assume that even people who subscribed to my account on X, Twitter, know who I am. Obviously, I'm a lawyer. My name is Ron Coleman. That much you knew. I have practiced law, focusing almost entirely on litigation, since 1990. I graduated law school from Northwestern University in 1988. I spent 2 years studying in yeshivas after law school before beginning my legal career. So that's why if you look up my credentials, you might think perhaps it took me 2 years to pass the bar exam or something like that. Actually, you wouldn't think that because you'd see that I was admitted to the bar in 1989, but I didn't actually start practicing until 1990. I have practiced in many, many different environments. Some relatively large firms, some medium-sized firms, on my own. I've never been in a nonprofit, although I've done lots and lots of pro bono work and worked with nonprofits. And I've never been in-house, but I've been around. I've done lots of different kinds of work. And one of the things, in fact, that I'm proud of in my experience is that I have a very varied background. I think that makes you a better lawyer, even if you end up focusing on one kind of litigation more than others, because you want to be as proficient and have as many tools and have as much instinct development as possible. And sometimes you can get sort of tunnel vision by only doing the same kind of thing over and over and over again. Now, the term litigation does also lead me to another interesting point. Well, I hope you'll find it interesting. I think it is. There are really two kinds of lawyers who do litigation. And you'll pardon me if I overgeneralize, but generally speaking, they are usually categorized either as trial lawyers or litigators. Trial lawyers are people who try cases and try them fairly frequently. I don't think there's any particular quantity that you could say, well, that's a trial lawyer and that's not a trial lawyer, but certainly multiple years would not typically go by in the life or the career of a trial lawyer without a trial. Litigators are usually associated with what's called the more corporate side of law, corporate litigators. They tend to be involved in much larger cases. And here's a little hint. The bigger the case, the less likely it is to actually ever go to trial. There are lots of reasons for that. One is that trial is an extremely risky endeavor. Another one is that it's an extremely expensive endeavor. So when you combine risk and expense, you've got a very, very high incentive to settle. You've also got, in all likelihood, insurance carriers involved. And when there are insurance carriers involved, well, they're experts at analyzing risk. So they almost always find the spot along that curve of risk and reward where it makes the most sense to settle. Cases hardly ever do get tried. In any event, your litigators focus mostly on getting things to the best possible position for their clients to avoid trial on the best possible terms. And that's winning. That takes a great deal of skill. And in some complex litigation scenarios, it can be extremely valuable, an extremely valuable skill. And in fact, many of the people who do this kind of work make millions and millions of dollars a year, even though they've never tried a case in their entire lives. They act, however, and practice their craft as if they were prepared to try. They are given budgets and resources that make it possible for them to, again, put their clients in the best possible position to convince the other side that if a trial does happen, they will regret it. On the other hand, or on the other side of the distinction that I've made, trial lawyers are the people, men and women, who are in court on a much more frequent basis. Some of them try many, many cases per year. It is very common for people who try a lot of cases to have started out their careers as prosecutors or as government lawyers who try cases. See, the interesting thing about the government is that its risk-reward ratio on trying cases is not the same as those of private parties, because money is pretty much no object, certainly for the federal government and for most state governments as well. That's something we'll talk about later on. The people who try cases on a regular basis have a certain amount of contempt for corporate litigators because they don't really do it. They don't really try cases. There's something macho. There's something, well, there is. Well, there is. There's something cool and something dangerous and intriguing about trying a case. That's one of the things I like to do the most, in fact. It is hard to get a case tried these days. Courts are backed up, especially in the areas where I practice, predominantly in New York and New Jersey, although I have tried cases in many places, Florida, Arizona. Clients lose their patience, or the other side loses its patience, or one side or the other goes out of business. And then that specter of settlement rears its head from time to time. Now, these two distinctions I made between the trial lawyers and the corporate litigators, it is fallacious to some extent. Many, many people fall in between. There are people who really try cases and hardly do anything that we would recognize as corporate litigation. And there are people who really, really, and never, ever try a case, but do the extremely important commercial litigation work. But in between those extremes, people fall in the middle, and I have to admit I'm in the middle. I'm more of a corporate litigator. I've tried more cases than most of the people in the large firms that I've worked with, and I started trying cases at an earlier age, at an earlier stage of my career than many people in those firms, but not nearly as many as people who are truly trial lawyers. That's the sort of culture of the litigators versus the trial lawyers. And what I hope to do again over the next, I think this is going to take us many months to get through the outline that I've prepared. But I know that people do have a lot of questions about this and that people do love to hear stories about this. And we'll talk also about alternative dispute resolution. I've been involved in a number of arbitrations, which are, as you know, basically private litigation. This private litigation can very much look like public litigation. In other words, court litigation, except much worse, much stupider, and much more expensive. We'll talk about why that is and why we're stuck with so much of it, and how there has been a profound misapplication of congressional policy that seemed to make sense when it was passed, but which has resulted in a great deal of injustice, in my opinion. We'll talk about the judiciary. You know, that's a favorite topic of mine if you follow me. And again, we'll talk about how it works, the scope of litigation, what things can and can't be addressed in a court. We'll talk about the difference between civil and criminal litigation, as well as administrative law and other sort of hybrid aspects of adjudicatory bodies that people might find themselves subject to. But for now, I want to thank you for joining me in this warm up. Hopefully, I'll get some encouragement. You can start asking questions immediately, and I will be checking to see if there are questions, and I will endeavor to answer them. So next week will be our next lesson on Wednesday, same time, same channel. Meanwhile, have a very nice evening, afternoon, morning, or whatever works for you. Thanks for joining me.